Every September 21st today, the third arm of government, the Judiciary, organizes the Benedicto Kiwanuka Memorial Lecture to honor the former Chief Justice who was disappeared by gun-toting security operatives and never to be again 53 years ago in the early days of Idi Amin's regime. The 1994 report, Pearl of Blood into Human Rights Violations between 1962 to 1986, detailed that between 1971 and 1979, little use was made of the various legal acts, such as the Public Order and Security Act 1967, Emergency Powers Act 1963, or the Emergency Powers Detention Regulations 1966, in arresting and detaining. Like to a great extent today, security personnel which operated under loose command structures without any introduction showed up knocking on the doors or waylaid and kidnapped people of whom were never seen again. About a dozen National Unity Platform supporters abducted by security before and during the 2021 election campaigns have never been seen again. No word on Sam Mugumya, who was abducted by security on August 28th. Several NUP supporters, including Eddie Mutwe Sebufu, who was abducted in May, and the Chief of Defense Forces General Muhoozi Kainerugaba, even bragged about it. And Noah Mutwe Mitala are languishing in prisons over flimsy charges, and their right to bail has been denied variously. Scores of NUP supporters were arrested during the last election campaigns and initially charged before the military court-martial in Makindye, but their case files were transferred to the civil courts following that January 31st Supreme Court ruling that stripped military courts of powers to try civilians. Despite spending more than 180 days on remands, the courts continue to play politics and have denied them bail. 4 times presidential candidate Kizza Besigye and his aide Haj Obed Lutale have thrice applied for bail after their files were transferred to the High Court's Criminal Division, which has been denied. Their request for the presiding judge to rescue from the case also has been denied.
If people are brought before you for bail, you know their leader is Chagulanyi, or even Chagulanyi himself or anyone else, you have to be careful. You have to look at the law and you have to balance it. Even if you're self-interested, you say, okay, yes, I'm looking at the current government, but at the same time, I did this for going power. Let me apply the law. Let me grant them bail, as the Constitution says. And that happens if you think there's a possibility of the president changing. But if there's no end in sight, the next elections are a foregone conclusion. The person is going to be there for the next 10 years. They're saying, I want Micah job. So you want to, you're magistrate grade 1, you want to become principal, senior principal, you want to become chief magistrate, you want to become registrar. You're registrar, you want to become a high court judge. The appointing authority, the Judicial Service Commission, you look at them. Who appoints the high court judge? So you don't want to annoy the president. Now, that is one dimension of the crisis. Because again, we use these words, then these are alarmists, but there's no other way, there's no other word to describe it. Because, again, as a product of that longevity, you now have one person who has appointed all the Supreme Court justices, all the Constitutional Court judges, Court of Appeal judges, all the High Court judges. That is unnatural, abnormal. It is abnormal. And appointed the JSC, that is abnormal because it basically means you have, and if you combine that with the fact that the president is still around, you have people who see this person as the way they are appointed and the way they are promoted.
As an advocate of the High Court, I am particularly concerned about the state of our judiciary because when citizens lose faith in the ability of the judiciary to operate independently and exercise its powers, then that creates room for individuals to resort to other processes.
There could be no moment in the 30 years of the 1995 Constitution that the judiciary is in dire need of soul-searching than today if it were to best honor the former Chief Justice Benedicto Kiwanuka. 2 of the judiciary's own, Supreme Court Justice Esther Chisache and Uganda Law Society President, are in exile over issues boiling in the judiciary. In everyday parlance, critics have argued that the third arm of government is in crisis mode. The head of the Law Department at Makerere University, Dr. Daniel Ruhweza, says the crisis is multi-layered.
And I do agree that the judiciary needs to do better, but I'm also aware that the judiciary is literally overwhelmed. Yes, there will always be bad apples that are called corrupt or that have made judgments that are poor or that have been appointed under questionable terms. All that is there. But the key remains. If you want to deal with issues such as backlog, you must have more judges.
He said Ugandans need to start demanding for more. The 1995 Constitution underlined an independent judiciary under Chapter 8. According to the Odoki report, the branch of government is charged with the responsibility for interpretation and application of the Constitution, and this role should be clearly understood to require the courts to rule upon the constitutionality of acts of the legislature, the executive, and the other governmental bodies. The Constitution recommended from lower courts at the magistrate level to the Supreme Court, specialized tribunals to legal aid schemes to administer justice, and other specialized bodies from JSC, Law Reform Commission, among others. All was well until the maneuvers to remove the presidential term limit started and the friction between the executive and other arms of government started manifesting openly. An independent judiciary is often hailed as one of the most important aspects of the rule of law. Critics argue that the process begins with independence and fairness in appointing judicial officers. The honeymoon ended on November 16, 2005 and March 1, 2007, when military personnel laid siege on the High Court to forcefully rearrest Besigye's People Redemption Army co-accused suspects. Since then, the executive has enjoyed an uneasy relationship. That also included financial deprivation with the judiciary. With a limited budget, it meant that the judiciary cannot hire judges, leading to case backlog, while thousands languish on remand, until a constitutional court ruling on the financial independence of the judiciary. In August 2016, supporters of the former IGP General Kale Kaihura, armed with placards, stormed the Makindye Chief Magistrate's Court in an attempt to block proceedings of a case filed by private lawyers against him and 7 other police officers over the beating of Dr. Besigye. The Chief Justice, Owini Dolo, underscored that the third arm has largely done well.
If indeed there was capture of the judiciary, then why do we make decisions which the executive is not happy about? Why do we make decisions which parliament is not happy about? How can somebody capture you and then urge you to write a judgment against him and then he complains? It doesn't make sense. So for me, the people should be happy that the judiciary, parliament, and the presidency work together. They should be concerned if working together means a sacrifice by independence. Because what is the independence of the judiciary? In the exercise of my judicial function, nobody gives me directives. In the exercise of a judicial function, the magistrate grade 1 cannot be ordered by the Chief Justice, decide in this way, not in this way. That's what independence is.
Corruption is commonplace.
So many times you blame court when the court should not be blamed. There are many times we could do things differently, I agree. But the lawyers, I see at times the lawyers, they appear in court and they are not talking the law, they are talking politics. Then I say, do they really understand that their clients are suffering?
There are, however, lingering issues such as the appointment and promotion of judges on the upper bench, from the High Court to Supreme Court, being at the discretion of the President and even in acting capacity for 2 years before being confirmed, which critics argue has a bearing. Constitutional law don Kabumba Businje says temporary appointment of judges puts judges in a tight spot to act impartially.
See, Article 126 Clause 1 says judicial power is derived from the people and must be exercised in accordance with the law and according to the norms, values and aspirations of the people. One of the ways of ensuring that is by involving the people in the administration, even appointment of judges and administration of justice. One of the unimplemented articles of the Constitution is Article 127 that says Parliament shall make a law providing for the participation of the people in administration of justice. It has never been implemented. So the best you have, I think, are assessors, but even then their opinions are not binding. In criminal cases, the judge can ignore them, etc. So really, one of the most undemocratic branches of the Ugandan government is the judiciary. Because yes, you have vetting, an appointments committee that vets them, but it's done in camera. There's no real participation of the people. Elsewhere, South Africa, increasingly Kenya, judicial vacancies are advertised. The applicants are shortlisted publicly. They sit interviews. In South Africa, they are open interviews. We can see what questions being asked. The actual public is asked, invited to send information about particular people. You're asked about your life story. You're asked to explain if you have been a judicial, explain previous decisions. So with that scrutiny, chances of getting judges who are alive to the struggles of their people and who are humble, judges who are humble, because that's also something that we're missing.
This against the backdrop of their senior deserving, rational and uncompromising on principles colleagues on the bench being overlooked for promotions while cadre judges advance quickly from High Court to the Supreme Court or being reassigned to head other branches of the judiciary. The list of names is long.
Because it basically means you have, and if you combine that with the fact that the president is still around, you have people who see this person as the person, the way they are appointed and the way they are promoted. They're not going to do anything. So in other words, they may not say it like the speaker crudely said it, but they're not going to do anything that causes displeasure to the president who is the instrument of the appointment. They won't do anything. That's why, again, you cannot conceivably see how there's going to be a Supreme Court presidential election petition. I'll be very surprised if Chagulanyi took one there, because you saw what happened the last time. Or we even have a justice who is in exile.
And they should have security of tenure. Security of tenure world over is one of the guarantees of independence. To know that I am appointed as a judge, I will deliver justice independently, fairly, and without fear or favor. The aspect of fear or favor is immediately eroded the moment you're appointed in active capacity. We've also seen these, as I said, these statements that are issued by the president or even some members of his cabinet threatening judges. That really undermines the independence of a judge, because judges are part of our society.
Such are the arguments of the Uganda Law Society in the sue against the Attorney General before the Constitutional Court, seeking interpretation and guidance on a range of issues concerning the proper application of the Constitution in relation to the Judicial Service Commission, which recommends names for appointment as judges to the President and has wide latitude. Critics argued that judicature laws and regulations spelled no criteria for the promotion of judges on the upper bench, from High Court to Court of Appeal to the Supreme Court. This has lowered morale, as many senior judges have stagnated at different levels or are routinely rotated from Kampala to upcountry stations, while others climb meteorically.
Because a judge should have the recognition that they are servants of the people. Now, if you're appointed in the night, you go to Parliament, no one even knows that you have been appointed, then quickly they see you at Parliament. That's what's happening. You just see some people at Parliament for vetting, within a week, someone just know that now this person is a judge. Now, that has created the possibility of really problematic appointments. Someone who not only lacks the temperament to be a judge, but in some cases actively should not be anywhere near the judicial office, to have the power over life and death, which a High Court judge has, or a Court of Appeal, the duty to interpret the Constitution and say what it means.
Elsewhere, in South Africa and increasingly in Kenya, judicial vacancies are advertised, a system that judicial reformers want introduced in Uganda. In South Africa, interviews are even conducted in the open for the public to measure the candidates' innate behavioral and emotional traits. While the regulations detail the removal of justices of the upper bench, there are not spelled out punishments for bad behavior and insubordination that do not necessarily warrant removal. This has allowed, among others, insubordination to thrive, as some judges take forever to write or issue judgments even for straightforward cases.
Judiciary is the arbiter. The state of Uganda can go into war if judiciary doesn't come in to separate the combatants. But it must come in the way the Constitution envisaged it. It must come in judiciously. It must come in with expertise in what it's doing. It must come in with the idea of justice. There's law, yes, there are facts, yes, but paramount above all these things is justice. I have heard rumors, and I don't want to bring rumors into the national debate, but there may be one or two bad apples in the basket. I'm now talking about corruption, and that apparently there may be one or two apples. If they are, and God forbid that they're there, the sooner they are rooted out and thrown onto the bonfire.
What we have is not sustainable. It's a non-starter. It's rotten to the core. It's one thing to talk about bad apples. We can no longer talk about bad apples. It is the question becomes, where is the good apple? You fail to find it. So even the person who has a good apple, if they rely on their appointment for a person who, if you rely on your promotion, if your promotion lies on doing certain things, inevitably you find yourself doing bad things. You will deny bail, and you'll have to find a way to justify it, and and do other things that are problematic. So even if you entered a game with a white shirt, if the game is dirty, you come out with a brown shirt.
However, with President Museveni in power for 39 years, there is consensus that there is executive overreach over the judiciary both explicitly and implicitly. Joram Paul Sonko for NTV News.